During the Senate hearing, Louisiana Senator John Kennedy grilled Sally Yates for refusing to defend President Trump's executive order temporarily banning travelers from certain countries. One America's John Hines caught up with the senator after that.
Sir, Senator Cruz had a line of questioning saying that that there's a Section 8 code which meant that Ms. Yates could have been fired because she wasn't following through on an executive order. And then she came back and said there was something with the I guess it was the Immigrant Naturalization Act, which, and then under the Equal Protections Clause, she felt that she was grounded. What are your thoughts on that?
Well, I don't know how many lawyers can dance on the head of the pen, but let me try to answer this from 30,000 feet. Ms. Yates, as Attorney General, as a lawyer, substituted her judgment for her client, President of the United States. Now, I think she was in good faith. I'm not suggesting she wasn't. But clearly, she substituted her judgment for the president. There are instances where that is appropriate. But to me, the only time to do that is when there are no reasonable arguments to be made in defense of the executive order or the statute. In other words, you'd have to go into federal court and make such a ludicrous argument that you could be sanctioned by a federal judge. I don't think that happened here. I think Ms. Yates, just in good faith, but it's just a fact, she just disagreed with the president's executive order. Now, she says it's unconstitutional. You know when an executive order or a statute's unconstitutional? When a court of final jurisdiction says it's unconstitutional. I may have an opinion about constitutionality, and Ms. Yates may have an opinion about constitutionality, and somebody else may have an opinion about constitutionality, but none of us are on the Supreme Court, and nobody appointed Ms. Yates to the United States Supreme Court. So when a lawyer starts substituting his or her judgment for the client, I'm not saying it should never happen, but you better be real careful. And I don't believe, in this case, and I'm talking about the first executive order and the second executive order. Everybody can draw their own conclusions about it. But I do not believe that there are no reasonable arguments to be made in its defense. You may disagree with the arguments. That's her testimony. There are no reasonable arguments to be made. In her opinion, it was unconstitutional. Well, no disrespect to Ms. Yates. I thank her for her service. But by God, who appointed her to the United States Supreme Court?
Where does it go from here, sir?
We're going to have another hearing. It's going to be classified, and we're going to get to the bottom of all this. I want to know who did the unmasking, and I want to know who talked to somebody else after doing the unmasking. I want to know how this stuff got in the Washington Post.
Thank you, sir.